Good afternoon, members. If I could have a nomination for chair, please.
Nominate Councillor Richard Adair.
Over to you, Chair.
Thank you very much. So, everybody, welcome to this meeting of the subcommittee hearing an application regarding cost cutters in Outram Road. Got to go through a few bits and pieces. So, to start off then, I'm Councillor Richard Adair and I'm a councillor for Nelson Ward in the city. The first thing I'd like to do is ask any declarations of interest. No declarations recorded. Okay, the housekeeping is, if the continuous fire alarm sounds, please evacuate the room and public gallery by the stairwells. Do not attempt to use the lifts. Please assemble at the Queen Victoria statue in the front of the civic offices. In order to comply with the Guildhall Trust fire marshal regulations, anyone who is signed into the Guildhall reception desk, please sign out and leave the building at the end of today's meetings. Please can everyone use the microphones and remember to switch them off when they have finished. Right, so I understand, but the case is going to be put by the licensing officer, Mr. Stone.
I just wonder if you want to do introductions.
Oh, sorry, yes, sorry, well spotted. So I've done my stuff. So I'm Richard Adair, I'm the councillor for Nelson Ward. I'll start to my right.
So I'm Councillor Lee Hunt, and I also help look after Nelson Ward.
To my left.
Good afternoon, I'm Councillor Stuart Brown, I represent Fratton Ward.
Shall we start moving around to the left?
Anna Martin, Democratic Service.
Derek Stone, Principal Licensing Officer.
Ben Attrell, I'm a solicitor employed by the council.
Yeah. Russell Angel, representing Home Office Immigration Enforcement.
I'm John Walsgrove, I'm solicitor for the licence holder. Next to me is Kumar, who is a director of the company which holds the licence and the DPS. And behind me is Jacob Cutler, who's working with me on work experience this week.
PT Ben Lewington, Hampshire Police Licensing.
Darren Bramley, Licensing Compliance Officer, Portsmouth City Council.
Lovely, thank you very much. I think we now move to where I was a few minutes ago. So, and the gentleman hiding in the corner, we've got a representative from the news, hiding pretty in clear sight. Okay, so we now move to the meeting. The licensing officer, Mr. Stone, sorry.
Could everybody speak closer to the mic? Because I have people hearing, I don't want to put this on today. If I could, I heard you, Jenkins, but sir, I didn't hear you too well. Could you ask my close to the mic? Yes, if you wouldn't mind. Thank you.
Okay, we're now ready to hear from the licensing officer, Mr. Stone.
Good afternoon, members. So the purpose of this hearing this afternoon is for the committee to consider and determine a review application submitted by Home Office Immigration under the Prevention of Crime and Disorder licensing objective. This follows a visit to Cost Cutter, 2 to 4 Outram Road, Southsea, on the 6th of August 2025 by the South Central Compliance and Enforcement Team, where they encountered an individual working at the premises who was identified as working illegally. Members, I won't go into any further detail regarding that, as you'll hear from Russell Angel, Immigration Enforcement, shortly. On receipt of the review, 2 additional support representations were received from the police on behalf of the Chief Officer of Hampshire Constabulary, and you'll hear from PC Ben Lewington shortly, and also from Mrs Humphreys, your licensing manager, who unfortunately can't make today's hearing, but her colleague Darren Bramley is able to give her representation. Both the police and Nikki's representations highlight recent failings at the premises with regard to the premises licence conditions. A copy of the premises licence is included in your papers. Members, if I can just mention a few things in my report. Paragraph 2.6 states that the prevention of crime includes the prevention of immigration crime, including the prevention of illegal working in licensed premises. Licensing authorities should work with Home Office Immigration Enforcement as well as the police in respect to these matters. Paragraph 9.25, when immigration enforcement exercises its powers as a responsible authority, it will do so in respect of the prevention of crime and disorder licensing objective because it is concerned with the prevention of illegal working or immigration offences more broadly. The paragraphs in my report on pages 3, 4 and 5 regarding the review process sets out relevant sections to this particular review. At paragraph 11.19, you'll see that where the licensing authority considers that action under its statutory powers is appropriate, it may take any of the following steps, and that is to modify the conditions of the premises licence, exclude the licensable activity from the scope of the licence, remove the designated premises supervisor, for example, because they consider that the problems are the result of poor management, suspend the licence for a period not exceeding 3 months, or revoke the licence. At 1127, you'll see it says there is a certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously. And it then lists a number of offences, one of which is for employing a person who is disqualified from that work by reason of their immigration status in the UK. At 1128, it states it is envisaged that licensing authorities, the police, the Home Office, Immigration Enforcement and other law enforcement agencies which are responsible authorities will use the review procedures effectively to deter such activities and crime. Where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. Members, I don't think I need to say any more at this stage because other people will have far more to say than I have. Thank you.
Right, we now move on to questions. Any questions from the members?
Not in regards to the report, no.
Councillor Hunt? Any questions?
I'm just thinking that through. Do we want to ask questions on what Mr. Stone has said or on the report that he has made or not?
You can ask questions on either. But I would stress that Mr. Stone isn't a party to the proceedings. So
He isn't.
it's more likely that the questioning will be to the
will probably
parties.
come up a bit later. All right. Thanks for the introduction.
Right. Anybody from the Home Office, any questions of Mr. Stone?
No, none.
The police, any questions?
No, no questions.
And the advocate?
No, thank you.
Right, we now move on to the applicant's case.
Okay, thank you, Chair. Can everyone hear me okay? Yes. Yep, okay. I don't propose to read through the full pack, but I'll make a few key points to explain why illegal working is a matter of real concern before I summarise the case. The ability to work illegally is a key driver of illegal migration. It encourages people to breach UK immigration laws and provides a means for migrants to remain unlawfully in the United Kingdom. It exposes individuals to exploitation, encourages dangerous journeys facilitated by people smugglers, and unfairly disadvantages legitimate businesses that do comply with the law. It can also impact wages for lawful workers and is often linked to wider labour market abuse, including unsafe working conditions. Illegal working therefore undermines the licensing objectives, in particular the prevention of crime and disorder objective. Immigration enforcement does not randomly target businesses. We're intelligence-led and act only where there are significant concerns. Nor do we routinely seek licence reviews. We do so in selected cases where those concerns are heightened. So turning to this review, which arises from an enforcement visit conducted to the address on the 6th of August 2025, during which immigration officers encountered an individual who did not have the right to work in the United Kingdom. The significance of this case lies not simply in the presence of an illegal worker, but in what it reveals about the management, supervision and operation of the premises. The evidence shows that this individual had become integrated into the operation of the business over a sustained period without the required right to work checks having been undertaken. The worker had been engaged at the premises for approximately 6 months. According to his account, the premises licence holder determined his working hours, allocated his daily duties and paid him in cash. No right to work checks were undertaken before he commenced work, nor were any documents or a share code asked for by or provided to the employer. This was not a momentary lapse or a single shift. The evidence indicates that these arrangements were operating over a sustained period of several months. The degree of responsibility given to the worker is particularly important. He explained he had opened the premises on the morning of the visit, an account which was supported by CCTV, viewed by officers, and accepted by the premises licence holder during interview on the day. Officers also recorded that he was the only individual present when they entered the store, that he was serving customers, and that he had the premises keys on his person. Those facts are highly significant and demonstrate that an individual with no right to work had been entrusted with substantial operational responsibility within the business. He was not simply present at the premises, he was opening the premises, serving customers, and operating the store by himself. The safeguards operating at the premises also give rise to concern. The worker confirmed that no right to work checks were undertaken before he commenced work. He also confirmed that he had received no training relating to food handling or the sale of alcohol, despite undertaking customer-facing duties and operating the premises in the absence of other staff. The manner in which the worker was remunerated is also concerning. He described receiving a fixed payment of £100 per week in cash, regardless of the hours worked, and confirmed that he neither held a national insurance number nor paid income tax. At £100 a week, there is a real likelihood that the worker in question was being paid well below the national minimum wage, which currently sits at £12.71 an hour. On the day of the visit, which was a Wednesday, the employee told immigration officers that he had worked from 8 until 12, 2 days that week, the Monday and the Tuesday, with a further 3.5 hours due to be worked that day, 8:30 till 12. By my calculations, that implies an hourly rate of £8.69 if it was just the 11.5 hours to be worked that week. May have been more on other weeks. The employer interview raises further concerns regarding the effectiveness of the management controls operating at the premises. The premises licence holder accepted that no identification checks have been conducted. When asked whether he was aware of the government's right to work checking process, he said he was not. He further accepted that he did not know the worker had no right to work because he had not checked his identification. The employer also described another individual who was training at the premises and explained that right to work checks had not yet been completed because they would be undertaken before that individual was placed on payroll. An explanation that's also relevant when considering the employer's understanding and application of the right to work checking requirements. Home Office guidance, which is readily available on the gov.uk website, clearly states that right to work checks should be conducted for all prospective employees before they begin their employment. Should this simple guidance have been followed, the licence holder would have prevented illegal working at the premises. The wider management controls in place at the business also merit scrutiny. During the visit, the premises licence holder stated that a training log existed, but was unable to produce it. He was also unable to produce any recent refusal records, with a hard copy refusal log showing a last recorded entry from October 2023. These matters reinforce the wider concerns regarding the effectiveness of the management arrangements in place at the time of the visit. Taken together, the evidence demonstrates a sustained failure to prevent illegal working alongside significant weaknesses in the management controls operating at the premises. These concerns are not confined to the matters identified during the Home Office visit. As you'll hear, there are also separate representations from the Licensing Authority and Hampshire Police raising concerns around compliance, management oversight, and the ability of the premises to maintain standards over time. Those representations reinforce the wider concerns already identified regarding the effectiveness and sustainability of the management arrangements operating at the premises. The civil penalty of £45,000 that was issued following the enforcement visit also provides further context. The company exercised its right to object to that penalty, and the case was reconsidered. The penalty was nevertheless maintained, no appeal was lodged, and as yet, no payment has been received, and the penalty remains outstanding in full. The Home Office does not rely upon the civil penalty as the reason for revocation. However, the response to the illegal working identified at the premises is also relevant when considering the future operation of the business. The The Home Office recognises that the committee has a range of powers available to it following a review, including the modification of conditions. However, the issues identified in this case do not arise from the absence of conditions. They arise from a failure to undertake the basic right to work checks and safeguards that employers are expected to carry out before allowing an individual to work. Licensing Act Section 182 guidance at point 11.27 outlines certain criminal activity that may arise in connection with licensed premises, which should be treated particularly seriously. This includes employing a person who is disqualified from work by reason of their immigration status in the UK. Point 11.28 states that where a review arises from such activity and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. It's clear illegal working was taking place at the premises, which, along with other concerns, including the refusal log, which hadn't been updated for nearly 2 years, as well as the points that will be raised by other responsible authorities, means the Home Office is not satisfied that the premises will be operated in a manner that promotes the licensing objectives going forward. For those reasons, Immigration Enforcement respectfully requests that revocation is the appropriate and proportionate outcome in this case. Thank you for your time, and I'm happy to answer any questions that people may have.
Thank you very much. I'll start the questions then. Just one, we're talking about 6th of August last year, almost a year. Why has it taken so long?
The civil penalty process that I mentioned can take some time, and the Home Office likes to ensure that that is seen through before taking action such as this. The penalty still hasn't been paid yet, so yeah, that's the primary reason. It's normal that we would wait for that to be considered before licensing action is considered, because if, for instance, there was no civil penalty, that may undermine our case in that they may have what we call a statutory excuse. They may have established a statutory excuse against that, for instance, provided some form of documentation that wasn't available at the time of the visit.
Yeah, okay. So I'll follow on from that then. Had the civil penalty been paid, would you still be asking for revocation?
Well, since it's happened after that, I think yes, we would, because of certain criteria that have arisen in this case. Like, as I said, these cases are treated particularly seriously. There is employment of an illegal worker who appears to be receiving below the minimum wage, even though illegal workers aren't subject to minimum wage legislation. That's still something to consider. And also, the illegal working is a criminal offence and undermines the licensing objective, yes.
Yep, thank you very much. Questions from members?
Good afternoon. Just a couple of quick ones. Has the Home Office considered prosecution for the illegal working offence, or was the civil penalty in lieu of prosecution?
Yes, in the vast majority of cases, we go down the civil route rather than the criminal route in these cases. We could have done, but we have gone down the civil route in this, yes.
And could you remind me, what time of day was the enforcement visit where you found the individual to be working alone?
It was in the morning. The worker had opened the shop at about 8 o'clock that day. I believe it was sometime after 9 a.m. in the morning.
And was he seen to be selling alcohol and tobacco to customers, or just regular groceries?
I'm unaware. There's nothing that says it was alcohol or tobacco. That's all I can say.
Okay. Thank you.
All right, then, a few things. Can I ask about the challenge log? Is that how you refer to it? I can't remember.
Refusals.
All right. So that's in written form, and there was nothing since October 23. So that's a period of what, 2.5 years?
Just under 2 years.
All right then. So my understanding is that these things are done on the till nowadays. For instance, when you're going to Lidl, there's a challenge immediately by age. I mean, did you ask to to see anything from the till, and was it produced to you?
My understanding there was digital evidence was asked for but was not presented.
So to be very clear, you have asked for that, but it has not been produced. Is that correct?
Yes.
And forgive me for going on, Mr. Angel. I feel like I'm on a movie, Mr. Angel. So how many opportunities did you give these people the opportunity to produce that challenge log? Because so far as we can see at the moment, unless something's said a bit later, there's absolutely no challenge to anybody for the best part of 2 years.
Yeah, I wasn't there on the day. The team asked to see it, and it was obviously shown the paper format, and it was asked on the day. I don't think it's been asked for by us since, by the Home Office since.
Well, perhaps the licensing authority might be able to tell us about that a bit later on.
Can I ask a follow-up?
Yeah. Can I go? Yeah, you go on. If it's on that thing, you carry on.
Yeah, I've just got a follow-up on that, which might be better answered by officers from licensing. Obviously, one of the conditions is that the paper or digital copy of the refusals log be made available to the police or to the licensing authority immediately on request. Does that requirement to present also apply to the Home Office when they request it? Because it only specifies police or licensing in the licence.
It doesn't, no.
Right then, so we've covered that. I would like to ask questions about the individual who was working. I mean, there's not a huge amount of for us to consider. We're told that the person opened up on the day that you called, which I presume is about 8 o'clock, and I don't know what time you went in, but what caused you to go there in the first place, or is that secret, as it were?
No, as I mentioned, we are acting on intelligence received. I can't divulge any specifics on that intelligence, but yeah, we received intelligence that illegal working was taking place at that premises, hence the visit.
Okay, any idea how old this person was?
I could find out specifics. It was in the, may well have been in the pack, the person was certainly an adult. Yeah.
A male?
Adult male.
Right, and secondly, how do you know that it was £100 a week? He told you that, did he?
Yeah, he was interviewed by the officers that were there. He told them that they recorded the Q&A on their smartphone device, and he signed it at the end of the interview to confirm that he had understood the questions and what was written was correct.
And you say the licence holder here set that person's hours of work a week. Do you know how many hours? Was it from 8 through till closure? Is there any intelligence on how many hours that person was working?
Yeah, the employee told us that, yes, and he said that he worked from 8 a.m. until midday on the Monday and the Tuesday of that week. The visit was on a Wednesday, and he said he was working from 8:30 till 12. He also said he occasionally worked weekends, usually from 8 till 12. He said he'd been working there for around about 6 months.
So may I understand then that he's working 8 a.m. to 12, that's the evidence, every day between then and sometimes at the weekend?
Wasn't clear what his pattern was over time, exactly how many days he worked each week, but he said he'd been working there for 6 months. That particular week was, as I said, he said he also occasionally worked weekends, but how often that was, I don't know.
So if it were a 40-hour week, he's getting paid £100 for that 40-hour week, and also sometimes at the weekend.
Yeah, it's £100. It was a fixed amount of £100, regardless of the hours that he'd worked. We haven't got any record of exactly what hours were worked over the full duration of his employment. All that is recorded was, all the questions he was questioned on was that particular week in regards to the hours that he'd worked that week.
All right, thanks ever so much, Mr. Angel.
So another quick one. You say he works basically sort of about 8 o'clock-ish to about midday. Do you know who he handed over to after he finished his shift, as it were?
No. On that day, I believe the premises licence holder arrived at the premises after he was contacted because of our visit. But on other days, I don't know who he handed over to, no.
All right.
And I don't know if he actually opened the shop on the other days, but on that particular in the shop, which was seen on CCTV by our officers and shown to the premises licence holder.
And just make absolutely clear, when you got there, he was the only person on the premises?
Correct,
So there was no person who held a licence to sell alcohol on the premises when you arrived?
Can I ask you a question? So in the interview with you, did he admit selling... thank you. In the interview with you, did he admit selling alcohol, this unauthorised person?
I don't believe that was covered. He operated the till, was what I said. What he said, sorry. So yeah, specifically that wasn't asked or mentioned whether he'd sold alcohol.
Yeah. Is that your role to ask those sorts of, or the Home Office role, or is that a different, is that the licensing authority's role or the police's role?
I mean, that doesn't necessarily, our role is to establish the legal working. It's nice to have an awareness of other...
All right, I put you on the spot a bit around that, I apologise.
No, we don't...
all right, I think these questions will come a bit later. I'm sure the others have noted what I'm thinking.
Something just popped into my head. Has the Home Office established the right to work status of any other people employed at the premises?
No, there was the one individual who was said to be on trial, but we don't know anything about them. But the premises licence holder did say that no right to work checks had been conducted for them either.
Was that no right to work checks for any member of staff or just for the person relating to this case?
Just for the person relating to this case and the person that was in training that had been mentioned. I don't know how many other staff.
I mean, I assume we can infer from the interview that he said he wasn't aware of right to work as a concept, that he hasn't done right to work checks on any of the staff.
Yes.
Okay, we now go. Any more questions from the police, first of all, to this gentleman?
No, nothing from myself.
Mr. Walsgrove, any questions? Okay. So we now move on to item 14, the responsible authority.
Sorry, Chair. Licensing authority.
Sorry, I'm jumping ahead. Right. So, okay, didn't jump ahead, now jump back. So now going to item 14, the responsible authorities request. So,
To myself first? Yes, okay. Yes, Peter Ben Lewington from Hampshire Police Licensing. We received the application to review the premises licence from Immigration, and we're of the view in support of that review application, as we're of the opinion that the premises was operating in a way that undermined the crime and disorder licensing objective, in the fact that they had illegal workers at the premises. I'm not going to repeat, obviously, what my colleague at Immigration has informed you of again, so I will move on. Obviously, the 182 guidance makes reference to illegal workers in licensed premises, which again has been highlighted, so I'm not proposing to repeat that. As part of my role as police licensing is obviously to do compliance checks at licensed premises. So on the 8th of February, I visited this store and completed a compliance check and found that it was in breach of a number of Annex 2 conditions, which are all highlighted on Appendix 1 of the bundle. Due to these failings, I then arranged a further compliance visit with the council as a joint visit on the 11th of February, and during this it was highlighted that there was more breaches of the licence conditions. Again, that is all highlighted in Appendix 1. I'm happy to go through them with yourself if you want, but if you've already read it, I will leave it at that. Due to obviously all these failings, and a lot of them related around to the sale of alcohol, the council took enforcement action on the DPS, and that resulted in the DPS receiving a caution from the council. Sorry, just to highlight that sort of between that time, there was further checks done at the premises throughout the month of February, which highlighted again that the breaches were still continuing, or some of the breaches were still continuing. Once these breaches had been identified, the DPS did engage with the local authority and myself and his solicitor to rectify the problem, and we did conduct a further visit on the 2nd of June, and it was established that most of the conditions were being complied with. There was a couple that he still weren't fully compliant with, which was he was unable to provide staff training and age verification policy, but this was sent through at the request of myself within a couple of days. Although this indicates DPS has taken steps to ensure the venue is compliant, this isn't an isolated case. Police records show that police made a representation for a variation of the premises licence back in 2016, and as part of that police representation, a compliance check was done and a number of Annex 2 conditions were noted to be breaching. Again, the police worked with the DPS to get these all rectified, and eventually they were found to be compliant after a period of time. There is evidence that a lack of compliance over a number of years, and even when these breaches have been highlighted, compliance has not been maintained long term. The identified issues highlighted above raise concerns of how the venue is managed and the DPS's ability to promote the licence and objective. So the police request that the subcommittee consider the points raised and give all consideration to the full range of powers and outcomes available to them under the Licensing Act. Any questions?
Yeah, just got one question. You visited the premises, I understand, on the 11th of the 2nd this year.
That's correct.
And you found then that there was a gentleman working, for all intents and purposes, who did not have a personal licence. Is that correct?
That's correct, yes.
I understand. So that person was not the same person that the Home Office visited. So a different person.
I believe it was a different person. I believe the local authority took the details and conducted checks with immigration to satisfy that he wasn't an illegal worker.
So the point I'm making, that on 2 occasions visits have been made to the premises and somebody who's got no right to sell alcohol was in the position to sell alcohol at those premises.
That's correct, yes.
Yeah. Okay. The other question I've got as well is, obviously the Home Office said they're intelligence-led. Did any intelligence be received by the police which suggested that the place was not being run as it should be run?
No, it was a random visit for myself back in February. There was no intelligence for it. My reason for visiting is right in the middle of a busy nighttime economy area. There's lots of comes and goings, so I thought I'd pop in and see it. There was no intelligence, no sort of reason. It was just a random spot check.
Yeah, okay. And also, we also heard that the original Home Office visited the premises back in August. Obviously, the gentleman working there for 6 months. During that 6 months, how many visits did the police make to these premises to see if it was being complied with?
What, in around August 2025?
Yeah, around about August. So say he's working there for 6 months. February to August. During that time, did the police make any premises visits to see it was being complied with?
No, say from August up until February, I've got no recorded visits there. My visit in February was the first one. As I say, that was completely just a random. And then obviously there was follow-up visits from February through to the point of when the DPS got a caution. And then I did a follow-up visit in June to ensure that the compliance was in place.
Okay, thank you. Members?
Yes, please.
Yeah, go on.
Thanks very much. I mean, I think Councillor Adair's last question answered this. I was going to ask if the premises was already on your radar for licensing issues, but I think you've answered that. There is one thing I want to just double check for the sake of clarity. You were mentioning breaches of Annex 2 conditions. The copy of the licence we have in the document pack, Annex 2 is blank, but Annex 3 has lots of conditions. And the breaches, I think, is spelled out on page 44 of the document pack.
Yep.
Did you mean the Annex 3 conditions?
I did. Sorry,
yeah,
my
just so that
apologies.
we're completely...
Yes.
I have about a different Annex 2 somewhere.
Yeah, there's about 19 conditions, so that would be the ones I'm referring to.
Yeah, so the ones
numbers
that are listed as having been breached is things like the absence of written authorisation to sell alcohol, absence for personal licence holder, failure to produce CCTV.
Yes, that's correct.
Yeah.
My apologies, a typo on my part.
No problem at all. And obviously, your representation today is arising because of the Home Office request to review the licence?
Yes, it is.
Yeah. Okay. Thank you.
Thank you.
What, may I ask what conditions were being complied with to find balance here? Were there any conditions actually being complied with that you could find?
So out of the 19 conditions, about 13 of them were being breached, so that would suggest that there's about 6 that were being complied with.
Right. The one thing that jumped out at me was age verification again. So I touched on it with the Home Office just now. Can you expand a bit more on the need for age verification and what was not being done, for example?
So the premises had an electronic point of sale system in place. So when a age-restricted product goes through the till, it will ping up to challenge for that age verification. So that was in place. The refusals register, as highlighted, was there and was produced, but didn't have anything since 2023. But obviously, the age verification is there for a reason, to stop children buying and obtaining alcohol or any other age-restricted products, tobacco included.
Right, okay. So even the police couldn't find, notwithstanding what the Home Office looked at, even the police couldn't find anything since October 23 to say that the premise, whoever was working there was challenging people over cigarettes, vapes, or alcohol, whatever they were selling there. There's just no age check at all.
So the point of sale the electronic point of sale system was in place. So as an age-restricted product, once that's scanned, it will pop up for them to challenge for ID. The refusals register is where they refuse to sell it for, it might be for no ID, it might be for the person being too drunk. So the refusals is slightly different to the challenge. The challenge is there to prompt the staff member to say, does that person look over 25, 21, whatever their policy is in place, is for them to then prompt them to make that challenge and ask for that ID. The refusals is at the point of
So once they challenge, the till, when the till suggests to them they should challenge,
yeah,
then entry goes into the refusal register, but there was nothing there for the advocate is shaking his head.
No, there was nothing in the refusals register, but I didn't check the point of sale on the till system, if that makes sense. So they might have been putting challenges in as recorded electronically, but I didn't personally check that. I checked the refusals.
And up until it, have they ever sent to you, said, by the way, we were challenging people, did they send that evidence to the police or anything like that? Have you ever had representation from the premises or his advocate that they had produced evidence that they were challenging people over sales?
No, I haven't had anything.
Would you have expected that if they had been, in their defence?
Possibly if I'd asked for it, then I'd expect them to send through a breakdown of it, but as I hadn't asked for it and I assumed or went along the assumption that the till prompt is there, so they will be using it because they can't then make the sale without clarifying whether that person's over the age of, of an age where they can buy those age-restricted products.
So between the police, the licensing authority, and in this case the Home Office, nobody has been told. They can't find anything that says that people were being challenged about their age. I would have expected to see something over 2 years. I mean, even I get challenged in little, but you would expect to see something, wouldn't you? Surely they would have approached you and said, by the way, we are complying with that, because you got down in your report about, you mentioned to us about the age verification. Surely they would wanted to have rebutted that by producing to you the evidence that said that they had been doing it.
So the age verification is a condition on the licence, which means they have to have a written age verification policy in place, which they did have. So the age verification policy might be that they've got that till prompt as part of their policy. So they've produced the age verification policy. I haven't had a breakdown of how many challenges they've had at the point of sale, but the refusals log, as I said, is dated back from 2023 when I visited in February. Thank you.
This may be something that we need to address to the advocate and the licence holder, but do we know whether or not actual refusals following a challenge are still meant to be recorded in the paper log, or if those are now part of the digital system?
That would be one for the other person. Obviously, if there's...
I will hold that question for the appropriate section.
I suppose my expectation is if they got a condition that they have to have a refusals log, it's normally whether paper or digital, but they need to produce something. On the occasion I visited, they produced a paper copy.
And the assumption being that if that's what you asked them to present and that's what they presented, that would be the thing that they should be using for all refusals?
Yes.
Yeah, thank you.
One more question. We live in very digital, social media aware times. Was there anything that you're aware of on social media to suggest go to Cost Cutters, there's somebody there who hasn't got a clue what he's doing, you can get alcohol very easily? Anything like that at all?
Not that I'm aware of, no.
Okay. Okay, so we now move on to questions then. Gentleman from the Home Office, any questions for the police? Mr. Walsgrove, any questions for the police officer?
Just the one in relation to... You mentioned there was a history and you referred back to the 2016 investigation, but it's just to ask you to confirm that actually there aren't any intelligence reports from 2016 until now regarding the shop other than the reports of your visits that you've set out in the application. So there's nothing in relation to this shop is causing the police any cause for concern other than your visits where you saw that the conditions were being breached.
That's correct. So all I've presented is what we have on our police records.
And you said you acknowledged that you were aware that the till did have a challenge system and would record refusals. Is that right?
I've acknowledged that the till had a age verification challenge prompt on it, but whether that recorded refusals, I can't answer that.
But you confirmed at your last visit all conditions were being complied with after the period of time that the applicant's been working with you, not the applicant, the licence holder.
So yes, so the visit in June of this year, the premises was complying with all the conditions that we were able to check. The only ones that weren't fully there would be providing the staff training and age verification at the time of the visit, but that was emailed through within a couple of days, I think it was.
So I think you did mention earlier on, and Mr. Walgrove prompted me again. So, but even in June, when we were going back to check that everything was mostly being complied with, we still have a problem around age verification. Can you expand on that? Why was there a problem around age verification? I mean, is this essential to this particular trade?
So the issue wasn't around the age verification, it was around the fact that he didn't have the document with his age verification policy at the store, but he did produce that a couple of days later. So there wasn't an issue around the age verification process because he had the challenge 25 and obviously the till prompts. It was just he didn't have that written document at the time of the visit clarifying what his age verification policy is.
But we know, don't we, from what's been said so far, that the person who was actually working 8 through to 12 every day had no training whatsoever about dealing with these licensing matters.
I would assume not, but I can't obviously comment on that because I didn't conduct that visit back in August.
I think the report tells us that the gentleman actually agrees that there was no training unless that's changed since.
No, I agree if that's what the report from immigration say it is, but as I say, I personally weren't part of that visit, so I can't comment on the evidence for that visit.
Okay, licensing, any questions to the police officer? No. Okay, we move on then to Mr. Bramley.
Thank you. So in relation to the recent application to review the premises licence, Licensing Authority made a formal representation in respect to this application on the grounds of prevention of crime and disorder. The Licensing Authority has also taken separate enforcement to the Home Office enforcement action in relation to the operation of these premises. A simple caution was issued on the 7th of April 2026 to Mr. Kumarasamy Yutham Rayan in respect of breaches of premises licence conditions contrary to section 136 of the Licence Act 2003. The caution followed compliance visits on the 11th of February 2026, 17th of February 2026 and the 15th of March 2026, during which a number of breaches were identified. These included the absence of written staff authorisation to sell alcohol, the absence of a personal licence holder on the premises when alcohol was available for sale, failure to produce CCTV, lack of staff knowledge of the licensing objectives, lack of training, the display of alcohol contrary to licence conditions, and continued breaches relating to staff working without the required personal licences. The caution records that the offences were admitted and accepted. A copy of the caution and the prepared statement are attached as Appendix A to the report. The licensing authority is mindful that the premises licence holder has, through a prepared statement dated the 25th of March 2026, accepted that the matters identified during the Council's investigation occurred, expressed remorse and outlined a number of remedial steps said to have been taken in relation to staff training, CCTV, authorisation, stock control and compliance with licence conditions. That statement also refers to subsequent visits by the police, during which the premises were said to be trading in accordance with the conditions. The licensing authority further revises that a joint licensing visit with the police was undertaken at the premises on the 2nd of June 2026. During that visit, it was established that the premises licence holder was complying with the requirements of the Licensing Act 2003 and the conditions attached to the premises licence. However, the members of staff on duty were unable to locate and produce staff training records when requested. The licensing authority recognises that findings of the most recent visit indicate that steps have been taken to improve compliance at the premises. However, those improvements must be considered alongside the significant and relatively recent history of the non-compliance, including the illegal working identified by the Home Office in August 2023 and the subsequent issue and acceptance of a simple caution in April 2026 for multiple breaches of the premises licence and conditions. In the view of the licensing authority, members may wish to consider not only the steps now said to have been taken, but also the extent to which those improvements are reliable, capable of being maintained and sufficient to address the seriousness of the earlier failings. The licensing authority considers that the matters set out above are directly relevant to the licensing objective of the prevention of crime and disorder. The facilitation of illegal working, failures to undertake mandatory checks, repeated breaches of premises licence conditions and weakness in management control all raise concerns as to the extent to which the licensing objectives have been properly promoted at these premises. The licensing authorities notes that the Section 182 guidance confirms that the 2003 Act provides a range of powers for the licensing authority for which it may exercise on determining a review where it considers them appropriate for the promotion of the licensing objectives. The guidance also states that where possible, authorities have already issued warnings requiring improvement and those measures have failed. Licensing authorities should not merely repeat the approach and should take the history into account when deciding what further action is appropriate. The licensing authority further notes that the Section 182 guidance identifies the use of premises for employing a person who is disqualified from that work by reason of their immigration status in the UK as a particularly serious matter. The guidance states that where the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. The licensing authority recognises, however, that each case must be considered on its own facts, and that it is for the subcommittee to determine what steps, if any, are appropriate and proportionate in all the circumstances. In light of the matters identified in this representation, the licensing authority respectfully invites the subcommittee to consider the full range of powers available to it under the Licensing Act 2003 and to determine what, if any, steps are appropriate and proportionate for the promotion of the licensing objectives. This may include consideration of whether a period of suspension or other measures available under the Act would be sufficient to secure ongoing and reliable compliance, or whether stronger action is justified in light of the history and the seriousness of the matters identified. Thank you.
And just one quick question. Obviously, we're talking about revocation as being the top sanction we could take. In your experience, how many premises have actually lost their licence through revocation?
You'll have to appreciate I'm fairly new to the as a licensing compliance officer, I've only been with the Portsmouth City Council for 3 months.
Okay, unfair question. I love licensing
Chair,
capacity.
I think I can probably just butt
Yep.
in and say that each case needs to be considered on its own merits in any event, so you shouldn't really be
Okay.
considering
Yep. Okay.
the number of previous revocations.
Members, any questions?
Good afternoon. So, looking at the Annex 3 conditions, specifically listed on pages 38 to 39, can we confirm that these conditions were in place before the enforcement visits by the police and licensing in late winter this year and before the Home Office visit in August last year?
Conditions in the licence, I understand, was 2016, so yes. they
So
would
yes,
have been in place.
super. And specifically looking at number 17, which specifies that a named individual shall not be the designated premises supervisor, can I infer from that that there was a previous issue at the premises which had to be dealt with and this condition was imposed because of that?
You'll have to excuse me, I've got no knowledge of that.
Mr. Stone perhaps might be able to answer.
incident.
Yes, basically that person was excluded from operating at the premises.
And do we know if that person is associated with the current owners and operators or management of the premises, or was it a previous iteration?
Sorry, previous.
Okay, thank you. I suppose going back to the issue of age restriction, have licensing officers since had sight of a paper or digital copy of the refusal log since October 2023?
To my knowledge, no.
I beg your pardon, what was the question?
Have licensing seen a copy of the digital or paper refusal log with any entries since October 2023?
No.
Thank you. That's it for now, but I may have more.
Okay, questions again. Then Joe from the Home Office. Any questions, Ms. Bramley? Oh, sorry. So am I jumping ahead? Go on then.
Thank you, Chair. Can I ask, I'll refer you to page 46, the caution. Okay, we're all up together, good. I mean, we've heard evidence today of a number of visits where sort of the premise was forced to start complying, but whilst I'm keeping an open mind, of course, I mean, in your experience, how common or otherwise is it for a premises that's selling alcohol to have a history like this of these sorts of breaches of the conditions? I mean, how common is this or otherwise? I mean, the police might want to pop in and say as well.
Obviously, I'm a compliance officer, so that's my work. It's what I do, and I spend a lot of time dealing with these issues. I think it's probably we do come across these issues. That is a fact. It's a fact of life. I think it probably.
But to get the state where you have to caution a person, they've obviously not been taking much notice to get to it. I mean, what kind of history do you have to have just to then get a caution? I mean, I would have thought that was quite a serious matter.
The licensing authority will always work with any premise and will take reasonable and proportionate action. And the action that was taken, a caution that was offered, was
I know you weren't here
appropriate
at the time. I'm sorry, Mr. Bramley. I know you weren't here at the time, but in there it says the staff member was unable to provide CCTV. Any idea what that means?
So on a number of different licenses, there will be conditions in relation to CCTV. That's in order to promote the licensing objectives, mainly the prevention of crime and disorder, and quite often the condition will relate to CCTV being present at the venue, and then a request for that to be kept, typically for 31 days, and then to be handed over to the police or licensing on request. That's a common condition on a license.
So this caution means that we know either wasn't CCTV on the premises, or that the CCTV was not on, or that, and I'm sure Mr. Walgrove will tell us in a minute, or that simply the person was unable to provide what was required at the time.
Yeah, so that states there, staff member unable to provide CCTV. So that request would have been made on attending, and the staff member was unable to produce the CCTV.
Forgive me, you weren't there, but what does it mean, was unable to provide CCTV? What does that
They
mean?
had no, it could, and you'll have to excuse me, I don't know the full detail.
Yeah.
They were unable, they didn't know how to operate the system.
Yeah, okay.
And therefore they couldn't produce either a disc or some way of either transporting that, sending that
But he-
footage as requested.
Nevertheless, admitted
time.
that it was in breach of that particular condition, you know, something which we, in this city, want in our taxis and premises all the time, CCTV, absolutely crucial to modern day trading.
Yes, I would agree.
I've just got one further question. Just a point of clarification. The interview, you've got the record of the caution. Just for clarification, cautions have to be admitted by the person concerned. You can't impose a caution on somebody. So all the matters listed are fully accepted by the party.
Yeah, there was a prepared statement as well, and that should be in your bundle as well, submitted as evidence, a prepared statement that was given by Mr. Tharan at the time. I'm happy to read out the prepared statement if you want, but that is in there as well. That would obviously make relevant sort of admissions in relation to the alleged offences, yeah.
Okay, thank you very much for that. So we move on. Do I get... Oh, you got another one?
No, just to clarify then, because this will need sorting out when Mr. Walgrove talks to us. There was a visit on the 17th of February, which we heard about earlier on, but it's recorded here. And there was a further visit on the 15th of March. And we did hear about some other visits too earlier. But written down visits that we're aware of in front of us, and that resulted in the end, like 3 strikes and you're out. Then he got a caution for the offences, which he admitted.
Yeah, typically the way this works is that, as happened on this incident, my colleague here, he went initially in February, raised the concerns, and therefore we did the first joint visit on the 11th of February, which in theory is the second visit overall. Then we then did this visit on the 3rd of February, which is the third visit overall, and then the one on the 15th of March, which is the 4th visit, and then after the caution, then my colleague then attended again. That was in June.
In fact, it's 3 visits, and then the 7th of April we got the caution.
Yeah.
All right.
So we've got Mr. Walgrove. Any questions?
Just the one. It's in relation to those visits and the issue of the caution. It's right, is it not, that both the licensing authority and police did not consider it proportionate to issue review proceedings in respect of those matters?
So yeah, the decision was made in relation to offer the caution. Yes, that's correct.
Thank you. And the licensing team, any questions? No? Okay. If I got it right, we move now to item 24. Mr. Walsgrove, I think it's for you now.
Thank you, Chair. If you just bear with me for 1 moment. First of all, as you've heard, my client accepted the position when he spoke to the Home Office officials when they spoke to him at the visit in August, and also in full cooperation with the Police and Licensing Authority in February when they visited and found breaches of the licence. So we're not here to dispute the facts before you, other than 1 or 2 critical things which I'll talk to you about in a moment. But on the whole, the facts are accepted. And Kumar would obviously like to extend his sincere apologies to this committee and obviously to the responsible authorities that it has been necessary to bring a review before you, and he accepts the perilous position that he's in. He's aware of the guidance, I've talked to him about it, and understands entirely that the starting point for this committee will be the consideration of a revocation of his premises licence. And it's my responsibility to put to you reasons why I think you could depart from that starting point and consider other remedies available to you, including suspension of the premises licence. So in essence, that's what my representations are going to focus on. One or two important issues around the Home Office case, which I would say are mitigating factors that you could take into account to depart from the Section 182 guidance, which says even in the first instance you should seriously consider revocation. Obviously you have that in mind. I hope what I have to say to you will persuade you to think otherwise and impose what I'll come on to in a moment, a suspension and conditions on the premises licence. The first thing to take into account is that Kumar, despite the failings which were identified from breaches of conditions, is an experienced licence holder within the city. So he's owned this particular licence premises for the last 10 years. You heard reference on the conditions to the name of another individual. Well, that was the person who previously owned the premises, and Kumar has no association with that person whatsoever. And you've heard confirmation from the police and the licensing authority that in that 10 years, other than, and I'm not lessening the seriousness of the breaches of the conditions, but other than that, there has been no cause for concern by Cost Cutter operating, even when they varied their hours to provide alcohol later into the early hours of the morning. He's also owned licensed premises and still owns licensed premises in Southampton, a Premier store which he's held the licence for the last 20 years, and in Broadstone, Broadstone Local, which also operates a post office. He's had licensed premises there for the last 5 years, and more recently he disposed of one of his premises, which was also in the Portsmouth City Council area, Highland Express, for which he'd held a premises licence for 5 years. Now that's a total of 40 years of licensed retailing across those 4 shops. And again, not detracting from the seriousness of the situation that we face with the breach of the conditions and the employment of an illegal worker, there have been no causes for concern around the licensing objectives and him operating those shops and selling alcohol across 3 different licensed areas for, in effect, 40 years of trading. And I ask you to effectively take that into account in mitigating whether you should consider revocation of the licence when assessing his credibility to be able to operate licensed premises within your city responsibly and to ensure that the law is upheld as far as particular mention has been made about underage sales, for example. He's never had that issue faced across those 4 stores in 40 years. The breaches of the licence conditions, I'll come on to the illegal immigration in a moment. The breaches of the licensing conditions, you've heard my client accepted responsibility for those and did work with the responsible authorities to resolve them, and the last visit a few weeks ago showed that all of those licensing conditions were being complied with. That was prior to him receiving the review application. So it's often said that people only respond once a premises licence review is commenced, but Kumar obviously had acceptance of his caution, accepted responsibility and sorted out to ensure that all the conditions are complied with. So again, I ask you to give some credibility to the fact that this shop is now fully compliant with the conditions on the licence. In my view, what was said in the application by the Home Office, and I'm still fairly sure, even though the officer said it wasn't the primary reason why they issued the review, was the non-payment of the civil penalty. And I'd like to just talk to you a little bit more in detail about that, because I think that's important for you to understand, because I'm sure you're sitting there thinking, wow, he was given a civil penalty of £45,000 nearly a year ago and it still remains unpaid, and you'll no doubt be thinking that that's is indicative of his poor management or his poor credibility as a licence holder. In fact, Kumar, after the visit from immigration, sought out professional advice. Now, I'm not going to name the firm that he used for that professional advice. However, they advised him to submit an objection, and forgive me if I get the terminology wrong about whether it's objections or appeals, but anyway, lodge an objection against the issue of that civil penalty. The correspondence went back and forth between this firm and the Home Office regarding that, and eventually, as you've heard, a decision was taken that the case put forward by that firm was not accepted and that the civil penalty remained payable. And that decision was taken, I understand, towards the end of November, and I think from memory that decision was notified to his advisors, but certainly Kumar had no knowledge. He wasn't provided with any information directly himself. It was sent to his advisors, advising them that the civil penalty was upheld, but that if he paid it by the 10th of December 2025, he could pay a reduced civil penalty of 31,500, I think it was. But of course, he had no idea that that decision had been taken. His advisors did not inform him that that was a decision that was taken. So he thought it remained outstanding. So it's still taken, that penalty was confirmed in December, so it has taken 6 months for a decision to be taken on the review. Now, regarding the civil penalty, the first that Kumar became aware that his case had been determined is when a third party tried to enforce the debt at the end of January 2026. And he received a letter saying that the debt was payable. So he contacted that firm to discuss it and to make arrangements to pay, but was informed by that company that they no longer had instructions to enforce that debt, and that in essence it had been returned back to immigration. And that they weren't able to discuss with him any way of making payment for that. And frankly, he's heard nothing since. So when the review papers were issued, and I discussed this case with him and he told me the advice that he got from this firm, I have tried to contact that firm to find out what the issues were, to provide a copy of their file, to provide any correspondence they'd had with Immigration Home Office or my client, and they have refused to provide it. I have made several requests to that firm to provide it, and they continue to refuse to provide me with any information, which frankly is appalling. I then made contact with the Home Office and Immigration team, obviously because we needed to establish where this debt now lies and how it's got to be paid. And eventually I did get a response which confirmed a company called Moriarty Law are now effectively the enforcers of that debt. So I got in touch with, I was provided with their contact details, I got in touch with them, and first of all, quite rightly, they said I needed a letter of authority from Kumar, which I duly got, and then they said they couldn't deal with it because I couldn't provide them with their specific reference number. I returned the civil penalty notice to them and said, this is the company name, this is the address of the premises, this is the individual concerned, here's the civil penalty, how can you not find this on their system? They replied and said, we can't find it on our system, unless you've got our number, we can't deal with you. Kumar then received a letter on, I think it was the 2nd of July, from Moriarty Law, so that's the first contact he's had from the end of January until the 2nd of July. And that letter now says the penalty is effectively paid to us, get in touch, and you can discuss making arrangements for payment, and that is exactly what he will be doing. So it's not a question of not paying it. He didn't know his objection had been upheld. He had received incredibly poor advice from this firm. I have experienced communications with that firm, so I can see why he was in that much difficulty. And thereafter, it appears that that civil penalty, nothing was done about it for 6 months anyway. That's not a criticism, because I know that the wheels of the civil service and debt collectors can turn slowly. I'm just providing that as an explanation to try and dispel from your minds that you should have anything negative in your thoughts about Kumar's non-payment of that civil penalty. He's got every intention of paying it and will pay it. And in my view, he's been let down considerably by a professional advisor, because if he paid it, I think from experience of other cases, and I know rightly your solicitor says you should treat every case on its merits, but if that civil penalty had been paid, I don't think we would be here at all, because the police and licensing authority confirmed they weren't going to review the licence for the licence breaches, because this premises doesn't cause any concerns, and he would have paid the civil penalty and would have carried on being compliant with the licence. So that's the civil penalty. I do want to talk to you, obviously, because you'll want to hear about the employment of the worker who wasn't entitled to work in the UK. And as you saw, Kumar was cooperative effectively in his interview and has accepted responsibility for that, which is why he's going to pay the civil penalty. He was wrongly advised to challenge it. I've seen that challenge. It was obviously going to be turned down. There weren't any grounds that advisor suggested that could possibly have overturned that civil penalty. But his explanation is this, that that particular individual was a student at Portsmouth University and had a visa to stay. He subsequently left Portsmouth University and obviously had no right to remain. Kumar wasn't aware of that, but he was aware that person was struggling financially, was homeless, and that he was doing odd jobs for people. He came into his shop, didn't speak to Kumar, but spoke to one of his managers asking for work, and Kumar accepts that the last thing he should have done was allowed the person to work at his premises for cash in hand, knowing that he hadn't carried out any of the right to work checks. Now, Kumar does employ a firm of accountants based up in London who deal with his payroll, and they do all the relevant checks for his members of staff. So you can have assurance and confidence that going forward that this situation is not going to arise again. He thought he was helping somebody out, entirely wrongly, because whether you think it's morally right to pay someone for work when they're not entitled to work, it is entirely irrelevant. The law is the law. He knows he shouldn't have done it. He's extremely apologetic for it, and he knows that his business is hanging by a thread, because frankly, if you decided to revoke his premises licence, this business could not possibly succeed. It's a convenience store, and I'm sure you've heard me say many times on off-licence applications, the ability to sell alcohol, tobacco, dairy, those sorts of products, the essential products which people want to buy under one shop, if you don't sell one of those, people go elsewhere. And that's exactly what would happen here. If Cost Cutter lost its licence permanently, eventually that local customer base would go to one of the other shops nearby, and his business would close. And ironically, wouldn't then be able to pay the civil penalty because he wouldn't have sufficient income from it. So with the conditions that we're going to offer, they do place the responsibility firmly only on Kumar's shoulders, because as I said, initially it was his manager who agreed to let this person work some shifts at the premises. Obviously Kumar became to know that the chap was working there and he knew he hadn't done his right to work checks. So as I say, not offering excuses, I'm offering the explanation as to what happened. But with the conditions making it his primary responsibility, and that no other member of his team, even his management team, can take on anyone for employment, and his responsibility to ensure checks are done, which I know is the law anyway, but if it's a condition on the premises licence, it makes that clear, that then we say, having complied with the conditions on his licence and having resolved all of those issues, you can allow the licence to continue onward. Now, because the seriousness of this situation does have revocation in mind, you, I'm sure, will want to consider that your decision should at least have a deterrent effect if you allow the licence to continue, which is why we're also inviting you to suspend the premises licence for a period of a month, which will see him have to remove alcohol from the shop for a period of a month, which obviously is going to hurt him financially, but is also going to act, as I say, as that proportionate deterrent from any potential future employment of an illegal worker, which I can assure you, having been through this experience of having awful immigration advice from a firm of professionals, having to face a review where his business is on the line, that in itself is deterrent enough. But we acknowledge your decision has to show that. And so unusually, I very, very rarely suggest to a committee that they should be suspending someone's licence. And that, as I say, should also give you assurance that he is taking this seriously and he knows what he's done is wrong, for which he is extremely sorry. I have printed out the conditions, but I'm going to read them out to you because in law I'm not allowed to produce a document unless everyone else agrees. So I'm just going to read them and then everybody can have a look at them. So in terms of conditions, we would propose the following in addition to the month's suspension. Premises licence holder will maintain on the licensed premises a physical or digital copy of all documents produced by any employee to verify their right to work, which shall be retained for a period of 12 months post-termination of their employment. All such documentation will be made available to the police, immigration or licensing officers on request. Right to work checks, this is the second condition, shall be conducted on all potential employees prior to their employment in any capacity at the business. Checks shall be in accordance with the Home Office Code of Practice for employers as current at that time. Next condition, the premises licence holder will maintain on the licensed premises a register of all employees to include their full name, date of birth, current residential address and national insurance number. The register shall be made available to police, immigration or licensing officers on request. No one other than the premises licence holder is permitted to authorise persons to work at the premises in any capacity. So in the future, that allows licensing, police and the immigration to turn up at the premises and demand to see all of the relevant documents that you're required to carry out to check. So not the somewhat more laborious process that they had to go through on the last occasion. So I say that those conditions do have teeth to them, and of course breach of those conditions, as we know from the fact he got a caution, is a criminal offence for which either criminal proceedings can pursue or a further review. Which really brings me on to the kind of final point of the presentation, where I've said I would hope you've got some assurance that there is credible evidence before you that he can comply with conditions of the licence, bearing in mind his track record, that if he doesn't do it, he knows this really is kind of last chance saloon. When you've had one review of a premises licence before a committee, if you ever appear before them again on a review, there's only really ever going to be one outcome, which would be revocation. So he is begging this committee to give him that chance, give him the chance to be able to prove himself, bearing in mind that none of his shops have caused any cause for concern over 4 different licensing areas over 40 years. not taking away the seriousness of the fact that he employed someone who shouldn't have been working, and for the wrong reasons. He felt sorry for the person. The last point to make is that that person was not being exploited, and you do not have evidence before you that he was being paid less than the minimum wage. The opinion of the officer that he was working more hours than the statement that he said he was earning £100 a week is not sufficient evidence on which to base the fact he was earning less than minimum wage. He wasn't even receiving a weekly wage. He would be paid for shifts that he worked. He wasn't on a particular rota. Kumar says the answers that he was giving on that occasion may have only been just for that week. Certainly, in his experience, the chap would only work 1 or 2 shifts per week. And yes, sometimes that might be at a weekend, and generally it was in the mornings. Kumar has to accept that he effectively allowed his manager to continue running the premises in his absence, when, as you may have read in the papers, he was absent from the premises for about 3 months, where he had to attend with his family over in Denmark to his sister-in-law, who had been diagnosed with terminal cancer, and he stayed with her and caring for her until her death, and only returned, in fact, to the UK the week before the immigration team turned up. Again, forgive me for mentioning that, because Kumar is not suggesting for one moment that's any justification for what happened. What he's trying to do is explain to you that was an incredibly difficult period during his life, where, yes, in relation to this person, he'd taken his eye off the ball. It should never have happened, but he absolutely has learnt a lesson. He's been to hell and back, not quite back, because he's still here in this committee, and it is really doing no more than throwing his mercy on you to say, look, I can run licensed premises responsibly. I have done that in the past. I can definitely do it in the future. Yes, you've got to be seen to be taking strong action, and a month's suspension of the licence is going to have that financial impact. That £45,000 civil penalty is going to have a lasting financial impact on his family, probably for the rest of his life, paying that. So if ever there's a thought in his head about compliance, the paying off of that is going to be there for a very long time indeed. So, councillors, I would ask you to do no more than I've asked you to do. Suspend the licence, add the conditions on. It allows much quicker enforcement in the future, and it ensures that Kumar would never employ anybody who wasn't entitled to work in the UK again. As I say, I do have those conditions printed out, and I can pass those round now, but obviously we'll answer questions, as I'm sure you'll have a few.
Thank you very much. Just one question about Kumar's. He's obviously got a number of premises. You're telling us those premises are run well, no problems, you run them for a number of years. So what, in essence, went wrong on this occasion? Why did this particular premises go so badly wrong? And I don't think we can beat around the bush. It's gone horrendously wrong. We've had people employed there selling alcohol, presumably to vulnerable people. And, you know, there's a whole host of things that could go horribly wrong. Having had the Home Office visit, a few months down the line, again, there's people there being sold alcohol by somebody who doesn't have a premises licence. I mean, it's a horrendous story. So what has gone particularly wrong with this premises?
Just picking up on the last point, there isn't any evidence that they've sold alcohol to vulnerable people. There isn't any evidence at all that they've ever sold alcohol to people under the age of 18. And in relation to that condition, it is an incredibly unusual condition to have on a premises licence that a personal licence holder should be on the premises at all times. I've only seen that on 1 or 2 licences in Portsmouth. It's incredibly rare. Those people in his employ are trained, and he does put them through the personal licence holder training. But you must appreciate, in retail, staff come and go, and there are times when you have to retrain people. So if for example, your personal license holders leave, you've got to get somebody else, they've got to do the course, they've got to get exam completed, they then got to get their personal license. And with the greatest of respect to the government and the personal license is not that difficult to get, and it certainly doesn't indicate anybody's professionalism in working in licensed premises. It is a multiple choice test where you have to score 27 out of 50. That, in my view, does not qualify you to work in a pub, hotel, nightclub, or off license. So you, with the greatest of respect, you seem to be attaching a huge amount of weight to the fact that there wasn't a personal license holder. And I accept it's a breach of the license, absolutely. But that doesn't mean the shop was poorly managed. It wasn't poorly managed. The licensing objectives were upheld, and you've heard there's 10 years of no concern other than the breaches of the license. In selling alcohol to the public, the people of Portsmouth, they have not had a negative impact by these breaches, many of which are effectively document breaches. Again, they're important conditions, but what I'm telling you, it doesn't impact on his staff's professionalism in serving the people of Portsmouth. The illegal employment of the illegal worker, hands up, he felt sorry for the guy. He knew the law. He knew he shouldn't have employed them. He did. It's a massive mistake for which he's going to pay very dearly. We're asking you not to put the final nail in his coffin by taking his licence away, which means the end of his business.
Thank you very much. Just to clarify the point I made, I'm not suggesting we've got evidence that alcohol was being sold to vulnerable people. The really point I want to make is there's a great potential for it to be sold to people who should not be sold alcohol. We clearly appreciate what you're saying about the licence, but if somebody has been trained, at least they have an idea of what they should and shouldn't be doing. And the reason I raise that question is we have a virtually non-existent refusals register, which certainly opens up the question that there's a very, very good chance that people who shouldn't be sold alcohol, i.e. vulnerable, underage, could well have been sold alcohol. That's the point I'm making.
Yeah, thank you. So just in response to that, all staff were trained. And although in the interview, the person who was working illegally said they hadn't been trained, they had received sufficient training to be able to undertake their responsibilities in selling alcohol, and knew about the till system where the refusals are recorded electronically. And, you know, the police and licensing authority have accepted they've never asked to see the digital log. That's why it's not been produced. Kumar doesn't actually get that many young people coming in trying to buy alcohol. He's got a very local customer base where all his staff know the customers, they know him, and people locally, after a while, they understand that they are going to get checked, which it's not that uncommon. As you know, I act for a lot of licensees within Portsmouth City. A lot of the refusals books don't have lots of entries in. What tends to happen is, and I think someone mentioned a national operator, I won't mention their name again, but with their electronic refusals, they will scan everything in generally before they do challenges, whereas independent retailers, they might see someone go to pick up 4 beers and they might say, look, if you haven't got ID, you know, don't bother going to the till and checking. And Kumar says, so when you do go to the till and it's scanned through, obviously they do the challenge 25. What they have never recorded, because they're not required to by the conditions, is how many times they then said, have you got ID? And the person produces the ID, because he says they do challenge and they do produce ID. I got him to, once the issues in February came to light, to now change his written entry, which he uses alongside the till, which he wasn't doing. He was just using the till effectively as his digital copy, as he was allowed to do under the condition. But he now uses both. So where challenges are made, I said it's important to record. If you've actually asked for ID and someone gives you ID, put it down, because that shows you are doing it. I can come to the committee as I am now saying that happens. You might not believe me, because you might think, well, he's bound to say that. So that is a new system that's been put in place the last couple of months and will continue.
All right, Ms. Ms. Woodward, I'm a bit curious because you put great store in the fact that Mr. Uttaratharan was retailing 40 years overall, taking into account all the other shops and so on. And you say that there was staff training. I just don't understand that, because on the 7th of April 26, he admitted that a staff member had no knowledge of licensing objectives, that no training had been undertaken. That's in the caution, he admits it. So why do you say that training has been taking place or has taken place? Is that since the caution or up until the caution?
Yeah, so what he's admitted in the caution is there as a matter of fact.
Yeah.
I mean, obviously, across those 4 shops, he has to train his staff. What he has historically been poor at is effectively record keeping, and so he's not able to. So in a criminal case where you are alleged to have breached a condition on your premises license, there is a defence where effectively a due diligence defence, and that's where Kumar's kind of business fell down, because his due diligence around the conditions which are recording refusals, training, etc., he wasn't, and as accepted in that caution, he wasn't maintaining that properly at this shop, because obviously only in those different premises he can't be at this shop all the time. So yes, he's rectified it, and I'm here to tell you that all staff will be trained. The condition about personal licence holders is a very difficult one, but is compliant with it. It may be, in the future that if personal licence holders leave, then that means he's got to work there all the time as the only personal licence until he gets somebody else back. So he now realises that he can't just train at this shop. He can't just train someone as he would do in his other shops. It has to go that one step further, and that's where he's been caught out.
You haven't explained why somebody who with such a wealth of experience around this trade employs an illegal worker. How, with all that experience, he employs an illegal worker, fails to make any checks, and then he breaches the licence in so many ways, not once, twice, but 3 times. Yet you say he's very experienced and that we should take that into account. I mean, they're contradictory from what you've said.
Well, they're not. You heard from the licensing officer yourself, the enforcement officer, that actually premises licences breaching conditions is actually common. More common than you would think, and more common than you would want. So the kind of paperwork side of things, production of CCTV where the condition says immediately, those sorts of conditions are breached frequently by numerous licence holders, not just in this city, but cities throughout the UK. It's about what the response is from those licence holders at the time that those breaches are identified, but more particularly it's about, well, has there been an impact in the licensable activities, a negative impact on the licensing objectives from the breach of those conditions? And that's where I'm saying to you that there hasn't been any negative impact. Yes, he's accepted he's breached the conditions, but actually that hasn't led to any cause of concern in that shop selling alcohol to vulnerable people, underage people, because that doesn't happen. And I've explained why he employed the illegal worker, and it's an explanation, it's not an excuse, it's not a justification. That guy was homeless, he came into the shop asking for work, needed food, and they allowed him to work some shifts and paid him for those shifts, and he got, in effect, more than the minimum wage, and you have no evidence before you to say that there was exploitation. So you absolutely can't say there was exploitation in this case, because there's no evidence that there was.
Can I ask one more time before Councillor Brown goes in? Why did he allow somebody who was unauthorised to sell alcohol, why did he allow that to happen?
he wasn't there at the time. In terms of the illegal worker, as he said, he had trained him in the responsibilities in selling alcohol. There's no record of that, and I appreciate the guy said he hadn't been trained, but he had been. Both the person, the illegal worker, and Kumar, when they were interviewed, as you would expect, were incredibly shocked, incredibly nervous, incredibly anxious about the consequences. And Kumar couldn't even remember, having the conversations or what questions were asked or what answers he provided. That, in fact, was what the professional advisors he went to see about the immigration issue kind of picked up on, and what they put forward to the Home Office, in my view, was not right. And as I've said to you, if that had all been handled properly in the first place, I'm convinced we wouldn't be here now.
So, Mr. Walsgrove, on your last statement there, are you saying that some of the information given in the interview to the Home Office on the 6th of August is incorrect?
From the person who was employed there illegally, that they had no training?
No, from your client.
No.
That's all correct. The employer illegal working interview that was conducted.
Other than that, he had trained the member of staff.
Right. So where it says that your client was not aware of the government right to work check, that's correct.
It is, because
So he's been operating this premises for 11 years with no knowledge of the right to work checks, which became mandatory in 2014. So does that mean that none of his staff for the last 11 years have undergone a right to work check?
No, they have.
They have. So
they're carried out by his accountant.
They're carried out by the accountant. Okay.
Yeah.
I see.
Yeah. That's what I said earlier.
Right.
So the accountants deal with the payroll. When he's going to employ someone, those details are sent to the accountant. Those checks are done.
So the proof of the right to work checks are stored with the accountant and not on site?
Yes.
So there would be absolutely no way for anyone to, for example, for the Home Office to walk into the shop and ask to see the right to work documentation for staff without it going via the accountant?
I'll just let me check that point.
I'm not done yet.
So the confirmation is sent through by the accountant, so he has them all electronically. So obviously if he's not working at the premises where they turn up, hence the conditions that I've offered to say that all of that documentation must be there and must be available. But he has the documentation, but just in electronic format.
So just to confirm then, all the other staff, either historic or current, who are employed via the accountants with the right to work checks, they are paid through PAYE, tax and national insurance is paid. It's just the one person, the subject of this discussion really, who wasn't.
Correct.
Okay. The other thing I've got to query is, you say we've got no proof of exploitation or sub-minimum wage pay. You've said that the only incorrect part of the interview carried out with the worker was him stating that he hadn't been trained, which implies then that him stating that he worked 4 hours on the Monday, 4 hours on the Tuesday, and 3.5 hours on the Wednesday for £100 that week is correct. Well, by my math, that makes £8.70 an hour, which is significantly below the minimum wage.
Yeah. As I said to you, he had no work rota, so there wasn't set days of the week, there wasn't set hours he was working.
But we're not talking about a regular rota, we're talking about this particular week and this particular instance, where on the Wednesday he said, I started at 8:30, And the day before, he said he started at 8 till 12, and the day
Yeah.
before that, he said he worked 8 till 12.
Yeah.
He was talking about particular days of a particular week in which he worked for 11 and a half hours and was paid £100.
We're not able to recollect whether those hours that he worked was representative of that £100. Kumar said he never paid him less than the minimum wage, and where he has said he was being paid £100 every week as a flat rate, that isn't correct. He wasn't being paid £100 every week. He was paid in accordance with what hours he had worked in a week.
Right, okay. But obviously we can't confirm that because there are no records of the hours that he worked.
There's no PAYE records, no.
Okay,
That's
thank you.
right. But equally, you don't have the evidence that he was working for those hours and being paid. That answer
Well,
in
we
the
only
interview
have
is
we
not.
only have his statement, yeah, which he gave to the Home Office.
Yes,
Yeah.
you have an answer he's given in an interview where, you know, I won't get into his personal circumstances because I think that's unfair. It's bringing in another nuance. But
Sure.
essentially, my view is you cannot rely on that one line in there, the hearsay evidence,
Okay.
as a conclusion to say it was exploitation.
I'm happy to move on. Your client paid this person in cash, paid cash in hand. Why wasn't he put on the POA system?
Because he knew he couldn't work. He wasn't entitled to work.
And when, I assume the issue with the accountants handling all the checks, that's been a long-standing arrangement for all the businesses, or is it a recent development?
That same accountant last 20 years.
Same account, 20 years. Okay, thank you. I've only got one other question, and I think it is coming back to the refusals log. I'm mostly focusing on the immigration issue as the core of the matter rather than licensing. Because as you say, the licensing breaches have been addressed now, and we have proof that for the last month he's been operating as a compliant operator. Is it currently a digital refusals log? So if somebody comes in the store and you say, this person looks under 25, press a button on the till, and you ask them for ID, and they say, no, I don't have any, and you refuse the sale, do you write that down on paper, or is it passed to the computer?
That's both. So the till system, if the alcohol is scanned, brings up the prompt challenge 25. If it's refused, that's recorded digitally.
Yeah.
But we are doubling up because of the issues about, well, is there gaps, is there any gaps? It's also written in the book,
So
and
he's
then any successful challenge is written.
So has he reinstated the paper register then? Because there was obviously a gap between
Yes.
October 23 when it wasn't being used.
That's right. They just relied on the
They were
till.
relying just on the digital system
Yeah.
for that. Yeah. Okay.
Yeah.
Things have moved on a bit since my 10 years in retail, which granted, I did leave retail 12 years ago, but I did spend 10 years working in a co-op, the last 2 of which as a deputy manager, licence holder and DPS for the store. So some familiarity with how retail certainly used to do it. And I can certainly say that part of our conditions was that every challenge had to be recorded, not just every refusal. So even when we challenged somebody and they had ID, we had to write that down in a carbon sheet log to prove that we were doing it. And I assume that a similar sort of system is now in operation for this premises?
Yes, it is, because of course the digital system, when it brings up the prompt challenge 25, you don't know whether, you know, if I turned up, I'm not expecting to get challenged 25. So it'll automatically bring up the prompt. They'll just press yes. They won't actually challenge 25. So the digital system is no proof that actually you are accepting ID and you know, validly checking it, which is why I've now got him to record those in his refusals book. So it's just a log. So a successful challenge will say, yeah, I challenged, a passport was produced.
Yeah.
That has never been
And a
part
lot of this
his
will depend
system.
on the particular software for the version of the EPOS he's using. Certainly I've seen some, for example, at self-checkouts in small convenience stores in town, where even buying a can of Monster or an energy drink, you scan that and it says verification needed. And when the person comes over and scans their pass, gives them the option of visibly over 25 or not under 25 ID seen, or sorry, under 25 ID seen, under 25 ID not seen and refused. Which options pop up on the screen for this particular EPOS?
Regrettably, his till system is not as advanced as that. So if it's refused, you can, I think he said there's, you can either refuse it for age or for drunkenness. So there's the two different refusals. But for...
So you can't refuse a police officer in uniform?
That's no longer the law.
Oh, is that changed? As I said, it's 12 years since I worked in retail.
You can,
so...
I mean, probably no one would, but you can, lawfully.
I did when I used to work in retail once, twice.
That was, yeah, that was part of the multiple choice questions that, but you can now. Anyway, so his till doesn't record if you have ID produced. It doesn't let you enter anything other than I sold them the alcohol, which is why we've added that into a manual record.
I mean, obviously not something that we can impose as a condition of a licence, but possibly think about an upgrade to the system so that the software gives you the option to record what actually happens in each circumstance, which will also make it easier for the people working there when the correct prompts come up on screen. It'll make the training easier.
Yeah, okay.
I have no further questions.
One more question. This subcommittee has heard what I think we can only describe as a flagrant, deliberate breach of the rules, the licensing rules. So something's buzzing. So rules. Who's doing that? Might be you. Sorry. So we had a considerable breach of virtually every item of the Licensing Act. We've heard recently that he has been compliant. The cynic might say that's because he realises the severity of the incident, of the situation he's in, and he's now decided to comply. What confidence can this subcommittee have that in a few months' time, 6 months, a year's time, he will not revert back to the way he was before? That's obviously our major concern.
It is your major concern, and if you recollect to the beginning of what I said, I did point out that that would be your major concern, that generally when I've appeared on review applications, the feeling is, oh, they're only doing it because a review application was filed. But all of this compliance happened before the review application was received. So the kick up the backside, for the colloquial term, was the investigation by the police and licensing, which led to a caution. Now, in working with the police and licensing authority to get all those conditions back into kilter and complied with, they've taken the decision not to review the premises licence. So all of that compliance was in place, and then along comes the illegal worker review application, and the police and licensing authority had representations in, quite rightly, saying, well, we're supporting the Home Office, as they would always do, and actually here's a bit of a history that we had back in February and March with dealing with the licence holder. But that confidence is the fact that the compliance was already in place before the review application was received, and the fact that your licensing authority and police were not going to review the licence for those breaches.
So just to clarify then, between the time of the immigration visit, which was August 2025, 6 months passed until licensing started investigating, and 8 months passed until the caution was in place. So what we're saying is that he was quite happy to operate for 8 months with breaches of his licence after having had a visit from the Home Office until licensing got involved.
I'm afraid you can't conclude that, because there's absolutely no evidence before February that he was breaching licensing conditions. The one that the Home Office point out in their review about the refusals log, as I say, there was an electronic log, so even that's not proven. You can't assume because he was caught in February breaching conditions that he was breaching them before. So I definitely ask you to cast that from your mind because you are not entitled to think that.
Then may I ask, please, in that period of time between August and April, who the personal licence holders for the premises were?
Well, obviously I can't do that. I can't suddenly produce his employees list and confirm who have got personal licences.
Was anybody other than your client a personal licence holder?
Yes.
Okay. And one of them was present at all times for that, during every shift for that 8 months?
With the greatest of respect, this is a review application on which your decision has to be evidence-based. You have no evidence there's any breach of a condition between August and February, so whether... I'm not in a position to answer questions about his staff between that period because I haven't sought any instructions because there isn't any evidence that I needed to cover before you. So I'm not trying to be difficult, and I don't want you to think that me not answering the question means that he has been breaching the licences, because
no, of course.
all I'm saying is you're not actually entitled to think anything between that period of time because there's no evidence to say on the balance of probabilities he was breaching the condition.
But on the balance of probabilities, it's very unlikely that the breach occurred on the day of the visit and not before at all. Like, you don't suddenly breach a licence and get a visit.
That's how law and evidence works. You can't make assumptions. You can only make decisions based on the evidence that's put before you. And the evidence put before you is that the first visit from the police in February was the first occasion on which conditions were breached. You can't make a finding of fact in relation to breaches of conditions other than those which are supported by evidence. And that isn't me trying to be clever, that's the law. And if you make a decision based on any other assumption, that would be wrong in law. It's not me just sticking up for my client, that's the legal position.
One more to finish off. I mean, sitting here listening to all this, the one thing that really rings my ears is there's been a complete lack of supervision. You know, the feeling when the cat's away, the mouse do play comes to mind. I mean, there's literally been very, very little in the way of hands-on day-to-day management of these premises, which is probably why we're in the mess we're in at the moment. Depending on our decision, are we going to get more hands-on management to make sure that the licensing conditions are fully complied with?
Yes, you are. As I mentioned previously, he had 4 premises. The Highland Express, he no longer has, which was sold in May. So that has freed up much more time. And obviously he needs to focus time on this shop because that's, as I said to you, his business is hanging by a thread. If you decide to revoke the premises licence, then he's got to spend a huge amount of time there because he won't be able to afford to pay other people to be there to work for him.
Is there any other questions? No, move on. Gentleman from the Home Office, any questions?
Yes, just one question about what happened to the second individual who had, at the time of the immigration enforcement visit, had recently arrived in the UK from Sri Lanka and whose right to work hadn't been checked at that point, who was apparently undergoing training.
Yeah, they weren't employed, so didn't work there at all.
Okay, even training is considered as employment if it's providing a benefit
so
to the business.
Following the visit, they were not working at the shop. Didn't.
Gentlemen, would you be kind enough to talk to us? Because your voices are going across rather than forward.
Apologies.
Yeah, I just asked what happened to the second individual who was apparently being trained at the time, who wasn't there on the day of the immigration enforcement visit. And Mr. Walsgrove said after that he wasn't there anymore, he left.
Yeah, he wasn't employed from that day forward.
So he wasn't employed, but the Home Office say that even training is employment.
So in his interview, Kumar said that there was one other individual who's undergone some training with a view to working. And yes, you're right, the Home Office said that training is employment, which I accept. But after that visit, obviously he decided, well, that it wouldn't be right to continue employing that person until right to work checks have been done, and that person just left.
Any further questions? PC Lewington, any questions?
No, nothing from myself.
Mr Bramley?
No, thank you.
And licensing, no question. So we move on to the next bit, which is item 29. The applicant will give a brief summary.
Okay, thank you, Chair. Yes, I will be brief. The committee has heard the evidence and has the review before it. The previously mentioned Section 182 guidance makes clear that employing a person who is disqualified from work by reason of their immigration status should be treated particularly seriously, and that revocation should be seriously considered, even in the first instance. In the Home Office's submission, this is such a case, as the employer appears to have knowingly employed the person whilst they had no right to work. He knew they had no right to work, in other words. Question today is whether the evidence provides the assurance necessary for this licence to continue, and the Home Office submits that it does not. Accordingly, Immigration Enforcement respectfully requests that the committee consider revocation of the premises licence. Thank you.
Thank you very much for the briefness. PC Lewington, if you'd like to summarise your case, please.
Yeah, I've got nothing really to add. Obviously, just in support of the immigration, it is a criminal offence to employ illegal workers in the premises. And my concern is around the breaches of the premises licence, given how many they were, and long term will they be maintained moving forward. As I said, I haven't really got anything more to sum up. Just obviously submitted for your consideration, and yeah, just submitted for your consideration. Sorry.
Okay, that's fine. Mr Walsgrove, your summary, please.
I don't know whether Mr Bramley had anything.
Sorry, Mr Bramley, I didn't miss you out deliberately. Sorry about that.
I'll keep it short. I've got nothing. I think we're aware of what's going on.
That was short, I like that. So now we come on to you, Mr Walsgrove.
I'm afraid mine won't be quite as short, but we'll keep it brief, because obviously I have spoken for a long time.
Can you make sure you go reasonably slowly? Not too slowly, but because I'm writing things down as well.
Oh, okay, fine. Obviously, as an experienced committee, you know that in a review, your decision should be only what is reasonable and proportionate to address the cause of the review application, and that your function is not here to punish the licence holder. That's where the civil penalty and the criminal law come into yourself. So I would ask, when you retire, to think about this question, and it's, what is the likelihood of Kumar ever making the same error again in both the employment of someone who is not entitled to work in the UK and in relation to breaches of conditions? If you have no confidence in Kumar that he wouldn't be able to do that, then obviously that will lead you to a conclusion to revoke the licence. There's no two ways about it. The guidance says that should be a serious consideration at first instance. But what I do say to you is, just think about what I've said. He's accepted what he did was completely wrong, has effectively repented for that and put things right, and has suffered a huge financial consequence in relation to both the civil penalty, which we are in discussions with to make sure that that is paid, and that's through no fault of his own, I hasten to add. And you've heard he's put all the conditions into place, and it's been confirmed that those are being complied with. So I say to you, the likelihood of him coming back on a review to this committee again, it is so far removed that it must be reasonable and proportionate to allow his licence to continue, with the modifications, with the addition of the conditions, which means all the paperwork must be kept at the premises to allow easy investigation. But to ensure and to act as an additional deterrent to the civil penalty, to feel as though this licensing committee had some teeth to its decision to impose a suspension of the premises licence for 1 month, for which financial hardship will serve as a further deterrent to ensure that he complies with his licence and the employment regulations in future. So I do ask you to give him that last chance, and thank you for your consideration. I'll pass these to your lawyer. I'm not sure anyone else wants to see them, but you may want to see them when you retire.
Well, thank you very much for that. So from the chair then, what I've got to do is to ask all... Sorry.
Sorry, Chair.
Sorry.
I'm just going to jump in very briefly. I do generally prefer to give legal advice in open session rather than when you retire to deliberate. There was one particular point that was raised by the licensing officer when referring to the statutory guidance, and in particular the stepped approach. And I won't recite the particular part of the statutory guidance, but in effect it was referencing the stepped approach where a particularly serious or dim view ought to be taken where there's been a previous warning. In this case, obviously, there's been the caution that's been administered. This is a rather peculiar case insofar as that warning predates or postdates rather the matter that now is before you for consideration and leading to the review. So I'm just bringing it to our attention that we have a unusual chronology of events, and so you should perhaps adopt or attach ever so slightly less weight, because that is a warning, if you like, that postdates the issues that you're now considering. So just that you need to frame it in that mind when you're taking the matters and applying the guidance to your consideration. I'm sure there'll be no objections to that advice, but if there are any, please do let us know.
Thank you for that clarification. So just to be fair then, from the chair, I've got to ask if everybody is happy they've had their say. So I'll go around in time. So, gentleman from the Home Office, anything further you want to add?
Nothing further, thank you.
PC Lewington, anything further?
No, nothing further.
Mr Bramley, won't leave you out this time.
Thank you. Nothing
Licensing team, anything further? And Mr
Nothing further,
Walsgrove.
thank you.
Okay, I think that concludes. Oh yes, members. Mustn't leave you out. No. No. Lee? No. No. Thank you.
Chair, I think it's probably, sorry, the acoustics seem terrible today. I would suggest a minimum of 40 minutes. Probably more realistically, we're going to be looking at an hour, I would imagine. Time you deliberate, make your decision, formulate your reasons, and then I'm able to write those down. So I would say a bare minimum of 40 minutes, but likelihood knocking on for an hour. But if you said a minimum of 40 minutes before the subcommittee reconvenes.
And can we add a comfort break into that? It's obviously been sitting here and it's quite warm.
In which case make it an hour then.
Make it an hour, yeah.
Back before 5.
Yep.
And for those of you who have done one of these before, if you do see us around the building, we're not ignoring you, we're not allowed to talk to you, so please don't try.